Hello and welcome to our next 10-minute talk. Today's discussion is around own interest conflicts and what to do if you make a mistake. I'm Corinne Staves. I'm a partner at CM Murray, and I'm joined today by my partner Andrew Pavlovic. He is a regulatory and professional discipline specialist, and he's particularly focused today, for the purposes of today's discussion, on his expertise in SRA regulation. So let's set the scene and get stuck straight in. Everybody makes mistakes. We know this. This is a fact of life. I've made loads. What's important from a law firm perspective is obviously to have systems and processes in place, including training and supervision, to try and mitigate the risks of mistakes happening. But despite that, even in the best run firms, mistakes will be made. There's loads of things you have to think about in the context of making mistakes. If you've got, for example, some kind of negligent advice or potentially negligent advice, you need to think about the internal reports, you need to think about discussing it with the COLP, you need to think about investigating what happened, how to stop it happening again, and those sorts of issues. What we want to really focus on in this short discussion is the question of the SRA implications of how to fix a mistake. The client aspects in terms of managing the conflicts between the client and the firm in that particular instance. So I wanted to go straight to Andrew and to hear his perspectives here. Andrew, let's say that the firm has realised that a piece of advice either was negligent or may have been negligent. Do you have to tell the client that a mistake has been made?
Yes, you do, unfortunately. so the SRA Code of Conduct for firms and individuals requires you to be open and honest with clients if things go wrong, and if they've suffered loss or harm, put matters right if possible. And those last two words, if possible, are there because there are some circumstances where you yourself can't put matters right because this own interest conflict has emerged. In terms of what you tell them, I don't think this rule requires you to sort of admit negligence or admit liability from an insurance perspective. And certainly you need to have insurers' approval before you did anything like that. But it does require you to say that this has happened and this is what we propose we're going to do about it. And depending on where you are and how the situation's arisen, the options might be, this is how we're going to fix it, or you need to go and take independent advice.
I'm really glad you raised that, because that's the next logical question, isn't it? So you've told the client's been understanding, they recognise that understands that mistakes can be made. And the client turns around and says to the solicitor, can you fix this for me? Can the firm actually act in fixing whatever the issue is?
Well, it depends, which is the typical lawyer's answer, but it depends whether an own interest conflict has arisen at that point. So an own interest conflict is defined in the SRA glossary as any situation where your duty to act in the best interests of the client conflicts with your own duty in relation to that matter. So in the context of mistakes, where a firm has made a mistake and potentially exposed itself to a negligence claim, the firm's interest might be to either mitigate or extinguish that negligence claim. But for the client's perspective, the best option could be to sue the firm. So, you could end up in a situation where the interests are diverged. Equally, it could be actually the solution is to fix something in a way which is aligned with the client's interests. So the SRA have actually got some useful guidance on this. And they talk about the sort of situations where it could be appropriate to continue acting in the circumstance where a conflict might emerge. And generally, the situations where conflicts are more likely to emerge is where the process, the fixing process is quite costly, complex. There are other parties involved who may need to consent. You may need to apply to court for an order. They might have an opponent who opposes the order, etc., etc. So the more sort of difficult it is to fix, the more difficult it comes to carry on.
So in a strict situation where there is a conflict between your firm and the clients, I'm understanding there that you can't act as the firm where you've discovered that there is actually an own interest conflict. You have to establish that there's no conflict, effectively.
That's right. And unlike other conflicts, like client conflicts, acting for two clients in the same related matter, or a confidentiality conflict, there are no sort of workarounds. So for those exceptions, you can have client consent and information barriers, etc. Where an own interest conflict arises, the client consent wouldn't in itself be sufficient. You actually have to go away and extinguish the conflict completely in order to act. And one way the SRA suggests you might do that in the guidance is by telling the client, this is what we think we should do, but you need to go away and get independent advice. And they actually suggest that the firm should pay for the client to get that advice. And if the client then comes back and says, right, I've taken advice, here's the bill, and this is what and I'm happy to go ahead with your proposal, that might be a situation where you've actually resolved the conflict and you're able to continue.
That's really useful, actually. So there, obviously, there is actually no conflict because the firms and the client's interests are aligned in terms of fixing it. That's really interesting. Thank you. And I suppose there must be risk of own interest conflict if you've got individuals within the firm who are taking on, say, some appointments. I mean, the one that comes to mind immediately is private client practitioners, for example, that take on trusteeships or executorships, perhaps directorships of companies. Do you think they need to think about the own interest conflicts there?
Yes, they do, and there should be a system internally for firms to register those interests. And then just careful decisions need to be made. So firstly, it needs to be made clear that for the purpose of any conflict searches, those interests are there. So you don't find yourself in a situation where the firm is acting adverse to a company where a partner has an interest or something like that. But then they also need to personally consider their own interests in the matter. One thing that arises in the context of deputyships is sometimes getting your own firm to do work. Usually that will be in the client's interest, but is it necessarily? Could it have been done cheaper somewhere else, etc., etc. So you do have to think a little bit where you have these personal appointments. On a firm level, you need to be able to spot them, and on an individual level, you need to be able to recognise where you could be putting your own interests ahead of the client's.
That's a really interesting one, actually, about the level of cost, and I take your point entirely that perhaps the work could be delivered cheaper elsewhere. Do you think the SRA will be sympathetic to an argument that it may be more expensive within the deputy's own firm, but the prior knowledge of, say, the person's affairs or circumstances is actually a factor which mitigates towards using the other firm, or indeed different skill sets, different expertise, difficult sort of levels of service? Do you think the SRA will be sympathetic to those arguments in return for a higher charge?
Yeah, I think they would, yeah. But I guess some of the rules around course of protection deputyships, they actually require people to go away and get quotations. And it may be that if one is slightly more expensive, but they have the prior knowledge, the prior expertise, that's okay. But if there was a massive jump, then it might not be enough to say, well, we've got the expertise. So I think it would depend a little bit, but I don't think they would look at it just strictly on who was the cheapest. But I think there has to be an element of justification.
Yes, I suppose that must be right with things like deputyships, where there's a bit more choice, for example, around trusteeships or executorships, where there isn't that sort of vulnerability criteria to be taken into account, that I suppose there's a bit more flexibility there, but doesn't remove the own interest conflict, of course.
Yeah.
And I suppose the other thing, so we've talked there about independent advice and the fact that the firm would probably presumably have to pay for the advice if agreed with the client. I don't think it would necessarily be fair for a client to turn up with a bill having taken independent advice. If it's agreed that the firm doesn't have a conflict and can act in sort of fixing the mistake that it's made, can the firm charge to fix the mistake it's made?
Well, generally not, because if all you're doing is putting right what went wrong, then not. There are some circumstances where you've agreed that a conflict has arisen, and you have to take limited steps just to progress the matter to a certain point, so the client doesn't suffer prejudice. So an example could be where you've realised you're giving negligent advice, but there's a court deadline in 2 days. And if you walk away now, the client's not going to be able to meet the deadline. So there, the SRA says it's reasonable for you to continue acting, even though you've established a conflict, just to sort of get that extension application in, or do something in a limited way to stop the client suffering further prejudice. You couldn't charge for that, but that's an example of some further work that you might have to do that is sort of justified or outside of fixing the issue. And then in terms of actually fixing it, again, that's not something you could usually charge for. unless wrapped into that was something that obviously you would have had to have done it anyway or something. But it gets quite complex trying to work out those type of things.
Yeah, no, I see that, and I suppose there's the practical point of preserving the client relationship, quite apart from the regulatory aspect. And then I guess finally, in terms of just pulling the strands together, if anybody is listening to this 10-minute talk and they've got a sort of mistake scenario that they've encountered within their business, and they're a bit worried that they might not have handled it exactly right, obviously, other than instruct you for sort of brilliant, great value advice, what other things do they need to think about?
Well, yes, I mean, self-reporting obviously to the SRA would be one of those things. So in the cases that the SRA has dealt with involving own interest conflicts, the most famous one is the case of Hal Jones. And in that case, the SRA gave the firm a fine of £5,000, and they defined the conduct in terms of their fining bands as being serious / moderately serious. And the test, as you know, for self-reporting to the SRA is where you have reasonable belief that there's been a serious breach of the regulatory arrangements. So I think if you find yourself in a situation where you've made a mistake and you haven't told the client about it at all, that would probably be something that would be reportable. And also, if you made a decision to carry on and then find yourself in a bit of a pickle and realise actually you've got that wrong, that should probably also be something that's reported in light of that case and the SRA's assessment of the seriousness of the conduct in that case.
Thank you, Andrew. That's really clear. I'm sure that's not necessarily what people want to hear, but better to self-report and get it out of the way than to find yourself in a situation where an issue is raised, perhaps by the client or by opposition, and to be on the back foot. Was there anything else you wanted to add?
No, nothing other than to say that I've actually just done a practice note on this issue for PLC's new practice management and compliance section. So if this hasn't dealt with any of your queries, then you can find the practice note on there.
Fantastic. Thank you, Andrew. That's really useful. Thank you very much for joining us for this 10-minute talk, and we hope you join us again soon. Thanks very much. Bye-bye.